I believe I'm too young to wear the hat of an old lady. I don't have that wisdom of the old ladies. Let me also add my voice in welcoming all of you to this afternoon presser, and I'll do all I can to be as brief as possible. Beloved Ghanaians, democracy will work only if we fight for it, says President Barack Obama of the United States. I swore an oath to uphold, preserve, protect, and defend the Constitution of the Republic of Ghana, and that I will do right to all manner of persons in accordance with the Constitution and the laws and conventions of Parliament, without fear or favor, affection, or ill will. I concluded the swearing of the oath with a call on God to help me. I'm very confident and have faith in God to see me through these dark days of Ghana and our young democracy. Ladies and gentlemen, I want to start this presser by disabusing and setting the minds of Ghanaians at ease. There is no constitutional crisis in this country. I repeat, there is no constitutional crisis in this country. The Parliament of Ghana is alive and working. Let nobody mislead, misinform, or disinform you and the country. The democratic system we adopted and enacted, as captured in the Constitution 1992 and fleshed out in various laws, processes, procedures, and practices, is what has been triggered, and it is working. Let us allow it to work. Democracy is about the rule of law. Let the law work. The democratic system we adopted and enacted recognizes that in the course of operationalizing the system, disagreements will occur and challenges and problems will arise. The system has put in place mechanisms, structures, and institutions processed to a winner-take-all government. The majoritarian system of parliament, where the minority have a say, but the majority have its way, was rejected by the voters. They rather opted for inclusivity, collaboration, consensus building, leaving nobody behind. The equal representation of the two major parties in Ghana, resulting in the composition of a hung parliament, to the voters is the better way forward for our dear nation. The expectation of the voters is this will lead to the constitution of a parliament where the national interest will prevail as against partisan or parochial interests. This is the context and the peculiar situation I have to preside over as a speaker. I'm the first speaker in the Fourth Republic in fact, in the history of Ghana, to work with a president who belongs to a different party, to work without a majority party in parliament, but with an evenly divided parliament, 137, 137 apiece. That is a hung parliament. Decision-making has therefore not been smooth sailing. As the Speaker of Parliament, I hold the balance in favor of the national interest, but sometimes bend backwards to accede to government requests because government has been given the mandate to govern. It is with this understanding I led the board of the Parliamentary Service and members of Parliament to provide procedural rules of engagement to actualize this goal and to provide for the possible types of government as envisaged in the Constitution. These possibilities include an election of an independent president to form a government, somebody who contests, as we have now, as an independent presidential candidate can be elected by the voters as the president of Ghana. How is he going to work with Parliament to get his or her business, that is government business, approved by Parliament? We have a possibility of a minority government where the voters vote for the president, but he has less members of Parliament, and that is a minority government. How is he going to get the majority members of Parliament to always approve his business for him to govern the nation? We can also have a coalition or a merger of parties' government. And the familiar one we know is the majority government. These are possible governments constitutionally guaranteed in Ghana. In the current hung parliament, the new standing orders of Parliament had to cater for such a government by a number of provisions in the standing orders. We also provided provisions for all the other options of government that I just explained. For instance, a day which we called a decision day has been designated in the new standing orders, where the Speaker, in consultation with the leadership of the House, will set aside to allow members of Parliament who are ministers and deputy ministers the opportunity to be present in Parliament to be counted in support of government position to ensure government business does not suffer for lack of government members of Parliament in Parliament. Despite the above, often the number of government members present still don't add up due to the nature of the duties and responsibilities of ministers and deputy ministers. The NDC members of Parliament, however, understood the situation and on a daily basis cooperated with the MPP members of Parliament to see government business through. In spite of this, the NDC members are said to be saboteurs of government business by the MPP members of parliament and the followers of the new patriotic party. Those of you who cover proceedings on a daily basis are witnesses as to how sometimes I have to look at the members of the NDC in a very stern manner, which made them give in to their objections, just to get government business going. Ladies and gentlemen, the powers of the judiciary ends where the nose of parliament starts. The Constitution is very clear on freedom of speech and of proceedings of parliament. Articles 115 and 116 grant members of parliament privileges and immunities of speech, debates, and proceedings on any matter or thing brought by a member in or before parliament by petition, bill, motion, or otherwise. And I want to quote the two articles to you. Article 115. There shall be freedom of speech, debate, and proceedings in parliament, and that freedom shall not be impeached or questioned in any court or place out of parliament. Article 116. Subject to the provisions of this article, but without prejudice to the general effect of Article 115 of this Constitution, civil or criminal proceedings shall not be initiated against a member of parliament in any court or place out of parliament for any matter or thing brought by him in or before parliament by petition, bill, motion, or otherwise. This means happenings in parliament must remain in parliament. So the court must, and has always been, hesitant to interfere in the proceedings and decisions of parliament. In the celebrated case of Tufor versus the Attorney General, the Supreme Court affirmed that happenings in parliament are a closed book. Despite these provisions, the courts are replete with debates and proceedings of parliament. Most worrying is these proceedings are initiated by some members of parliament, even leaders of parliament, who ought to know better. Parliamentarians who are to be loyal to parliament rather than to the Supreme Court run to the Supreme Court at the slightest opportunity to use the Supreme Court to undermine parliament. This might be one of the reasons parliament and members of parliament are not respected and treated with disdain. This was exhibited by the president's refusal to even receive the LGBTQ+ bill, duly processed and passed by parliament without any legal basis. The judiciary is supportive of this conduct by the receipt and processing of a suit on this subject matter. These are dangerous precedents in our democratic journey. Both the president and the judiciary have sinned against the Constitution and must seek the opportunity to confess and repent to be forgiven. I am confident the battles we are fighting today will make our democracy stronger and more vibrant in the future. I believe in the supremacy of the Constitution. Mark my words, the supremacy of the Constitution, not the supremacy of the judiciary or Supreme Court. I also believe in a vibrant parliament that is respected and accorded its due on political questions as long established by law and decided cases. A parliament that understands, reflects, and embodies the will of the people and defends its constitutional prerogatives only works in the interest of Ghana and Ghanaians, not a rubber stamp parliament subservient to the whims and caprices of the executive and or the judiciary. Again, I strongly believe that Parliament was one of the institutions President Barack Obama had in mind when he opined, while in Ghana in 2009, that Africa needs strong institutions and not strong men. I'm happy he didn't add women. Parliament must be strong to perform its legislative function and the indispensable function of holding the president to account. That is the oversight function. No other person or body has the gravitas and constitutional mandate to do so in Ghana. The public, media, civil society, and other partners in governance can make constructive inputs and criticize actions and omissions of arms of government. But these bodies are not constitutionally and legally structured and mandated to hold the executive to account. Parliament is elected. It is, at its best, the will of the people, legally and constitutionally structured and mandated to do so. Ladies and gentlemen, my dream, therefore, is a patriotic one. The existence of a firm, effective, efficient, and responsive parliament whose members place national and constituency interests ahead of narrow partisan or personal interests. At last, this is yet to materialize in Ghana. Parliament weakens itself when its members keep running to our courts to settle or seek favorable determinations of not just legal matters, but essentially political and governance questions. It is my strong belief the matter before the Supreme Court can be settled within Parliament through matured deliberations and compromises. Please, make no mistake. Not all the strong men President Obama warned us about come in military uniforms. Some come dressed in suits. I hope in my lifetime, Ghana shall have a parliament and a speaker who are truly independent from Jubilee or Flagstaff House or any headquarters in the conduct of parliamentary business. Let me state unequivocally, Parliament owes its duty to the people who established and elected its members to serve and represent them. The wheels of Parliament will continue to turn, and no person will be allowed to disrupt parliamentary proceedings or to undermine the democratic mandate of Parliament. When I ruled in January 2021 on the issue of which side constitutes majority and minority in Parliament, the ruling was in favor of the majority group then. It was not an act of lawlessness as to cause constitutional crisis. When I ruled in the matter of the vacation of seats by Honorable Kennedy Ajapong, Honorable Henry Korte, and Honorable Sarah Adjoa Safo, the question of the interpretation of the Constitution was not raised. When my predecessor declared the former seat vacant in 2020, applying the same provisions of Act 97, the original jurisdiction of the Supreme Court to interpret and enforce provisions of the Constitution was not invoked. Peace reigned in these instances, and nobody cried and ran to the Supreme Court under the guise of constitutional interpretation. If I may ask, is it a legal matter for the Supreme Court to decide as to which side of the House constitutes the majority or minority? It is for good reason that justice is said to be blind, and further, that justice must not only be done, but must be seen to be done in all cases, not in only those cases to which some people appear to be sentimentally attached. Fellow Ghanaians, I respectfully call on the Supreme Court to apply the same swiftness with which the motion ex parte in the Eastern matter was granted to the case involving the President's refusal to receive the Human Rights and Family Values Bill passed by Parliament, which has been pending before the same court for almost a year without being heard. Ladies and gentlemen, consistency is not just an ideal, but the foundation of life. The court cannot enjoin 4 members of Parliament from serving their constituents for 12 weeks, but was very eager to deny the constituents of Assin North their representation because of the issue of allegiance. The court cannot deny the constituents of Sal the sanctity of representation for years. The court cannot even see that the Constitution itself permits a denial of representation within 3 months to the holding of a general election. It's in the Constitution. Ladies and gentlemen, the Parliament of Ghana shall commence sitting as by law prescribed from tomorrow, November 7th, 2024. I have earlier instructed the Clerk to Parliament to transmit the LGBTQ+ bill to the President for assent. Ladies and gentlemen, finally, I'm aware of the business the government wants to transact through Parliament, and I'm willing to cooperate and collaborate with government. Despite all that I have said, Ghana first. And all Ghanaians should bear the president, parliament, the judiciary, and all our leaders in prayer for the betterment of our people and country. With this, I thank you all for your attention. Assalamu alaikum.
The Right Honourable Speaker of the 8th Parliament with that address. May we please be seated. This is the Speaker's press conference, and he will now take questions from members of the media. We will take them in tranches of 4. Please, brevity is the name of the game. So you get up, you tell us your name, your media house, and then your question. In order for us to get as many questions in as possible, one man, one machete. And please, the preambles, let's just use them. The Director of Media Relations will assist in this particular endeavor.
Thank you very much. Mr. Speaker, my name is Ibrahim Al-Hassan. I report for GH1 TV and Star FM. Okay, so one man, one question. Mr. Speaker, I just want a clarity. Have you re-instructed the clerk to resubmit the Human Sexual Rights and Ghanaian Family Values Bill to the presidency, or you're relating to the old instruction you gave, which was rejected during the transmission?
My name is Kwame Minka, TVXYZ Power FM. My question is simple. So tomorrow as Parliament sits, tell us exactly how the sitting arrangement would be. Because what we've been hearing is that the minority then has its majority, and would they remain as such, or there will be a shift? Thank you.
Thank you, Mr. Speaker. My name is Akufu Asante from Joy News and Joy FM. Mr. Speaker, during the proceedings in court, the Attorney General had cause to say that you had committed a crime by illegally procuring the services of Mr. Sori in litigating those matters in the Supreme Court. Specifically, he puts out a letter that has been signed by the PPA CEO rejecting a sole source procurement that you wanted to do as regards to Mr. Sori. Please, can you respond to the specifics and allegations that you had committed a crime in that regard?
My name is Havila Kekeli, Class FM. Right Honourable Speaker, there have been several occasions where members of Parliament sometimes, through disagreement with some of your rulings or pronouncements on the floor, use certain words at you. How do you feel about some of these things?
Mr. Speaker, we will respectfully take a 5th one. We'll take a 5th one because of the brevity of the question, so that we can get as many questions in.
Thank you very much. My name is John Amensa, and I report for GBC Online. Just to reiterate the point earlier made by my colleague. Speaker, as we speak today, the media, we are somehow confused. You address MP as a minority leader and or a majority leader. You are told that, please, that's not my title. Or they'll just cut the line. Please, can you settle this debate for us? Who is the majority leader today in Parliament?
The Right Honourable Speaker. Mr. Speaker.
These are very interesting questions. The first one is easy. It's a fresh instructions to the clerk to Parliament to resubmit the bill to the President. I'll leave it at that. The second one, please, it's not part of the duties of a speaker to decide where an MP should sit in Parliament. It's not my duty. That determination in Ghana's situation, in various parliaments, these things we are talking about, majority side, minority side, don't exist any longer. That's why in my ruling I use the term old school. The British model, government, opposition, benches, and a carpet in between them. And so when you are shifting your political leaning, you have to cross that carpet to the other side. And that is why you have the term carpet crossing. Our parliament is not arranged in the form of government and opposition. And Ghana don't like the term opposition. So we decided to adopt the terms from the United States of America, majority and minority. So you can even sit anywhere. But the numbers determine who is majority and who is minority. But in our parliament, the practice is for those who constitute majority to sit at the right side of the speaker, and those who constitute minority to sit at the left side of the speaker. That is because after independence in 1957, we adopted the Westminster system, which is practiced in the United Kingdom. But we changed that, even to the extent that the arrangement on the floor of the House is in a horseshoe. So it's not always the case that the people to the left side are all members of minority. That's not the case now. And there's good reason behind this. As in the textbooks. The determination, therefore, in our situation, as to who constitute majority or minority, is a question of numbers. As to where they sit, is the determination first of the political parties who influence who should lead the caucus or party wing in parliament. They, after various consultations, decide that these 5 people should occupy these positions in leadership. And so they are given the chairs in front. Then in consultation with them, the 5 leaders, they determine who should sit behind them. Because as a leader, you need somebody that you have trust, confidence in, who has the capacity, so that when you are in some difficulty or you have a challenge, you can just lean over and listen to his or her whisper. So you have a say as to who sits behind you. The speaker is not involved in this. The whips, particularly the chief whips, lead in trying to identify who should sit behind. And it also has to do with years of experience in the House, and also the issue of gender and other professional backgrounds, until you get to those who are at the back. Even though we don't sit on benches, we still use the term backbenchers. The speaker is not involved in this. After they have agreed on it, they then get in touch with the parliamentary service through the clerk, who will get his officer at the table, together with the marshal, and they will get the names, print them, and place them on the various tables as decided by the various caucuses. The speaker don't come in this. Please. How can you call speaker to come and decide where people should sit? It's not part of my duties. Number 3. I will plead with you. Go and look at that letter. He's the Attorney General. He did his service in Parliament here. I was leader then, when he was doing his service here. Yes. So I know him very well before he became Attorney General. Read that letter carefully. And that's one of the things they are missing. There's vast difference between Parliament as an institution and the office of the Speaker. The Speaker is the party before the Supreme Court, not Parliament. So as Speaker, when the Attorney General is taking a different position from my position, I should still contract him as my counsel. I will leave it at that. Once I'll meet the Attorney General and I'll tell him my peace of mind on some legal issues and pronouncements he made at the Supreme Court. You know, Attorney Generals must be respected as learned. But it should not be part of what Obama referred to. Not me. It will not work. Number 4. As for the terms they use against me, it's part of the hazards of the work. We're doing everything as leaders, not to bring up